Today, Keith and I are going to demonstrate the negotiation of the fraud-related provisions in the acquisition agreement. Before we start negotiating, I'm going to quickly turn it over to Jane. So remind us, exactly what are we talking about here when we talk about provisions relating to fraud? What's the legal definition of fraud in the M&A context?
It's right there on the slide. It's really very basic, and there are variations from state to state, but generally under state law, a seller commits the civil tort of fraud if they make a materially false representation to the buyer and make that false representation with scienter, with an intent to deceive. In other words, with knowledge that the representation is false, and the buyer relies on that representation and suffers damages as a result. So we're not talking about a mistake or mere exaggeration, and we're not talking about puffery or marketing words. We're talking about a lie that was intended to be made.
It is tough to prove fraud, but if the buyer can successfully prove fraud, it gains access to some pretty powerful remedies that it wouldn't otherwise have, including uncapped damages, punitive damages, and rescission. Let's put up the fact pattern for today's negotiation. My client is the founder and the sole stockholder of a sizable technology company, a Delaware corporation that we'll call TechCo. Keith's client is a buyer that wants to buy TechCo by purchasing 100% of the stock of TechCo from my client, the sole stockholder. So my client will be the seller in the contemplated transaction, selling all of the shares to the buyer. Keith and I are in the midst of negotiating the definitive stock purchase agreement. The parties have settled on a purchase price of $150 million payable in cash, and Keith and I have spent the past week working through the reps and warranties and working through the indemnification provisions, and in particular, the negotiated limitations on those indemnification obligations. And I want to applaud you, Keith, for your being so uncharacteristically reasonable in our negotiations. We've settled on a 10% escrow and a 10% cap on the seller's liability to the buyer for breaches of the general reps. So thank you for being so constructive in your approach.
What can I say, man? I'm a fair negotiator. I'm a deal maker, man. I'm not a deal breaker.
Well, I hope you're going to be equally constructive in negotiating all of the fraud-related provisions you've included in your draft, because that's what we're going to turn to next.
That's great, because I hope you'll agree that the fraud-related provisions I've included in my draft are reasonable and customary. I've included basically three pieces: a customary definition of fraud, a provision preserving the buyer's fraud remedies, and a customary fraud indemnity. So once you look at it, I doubt you're going to have any problem with it.
First, I'd like to take a step back as part of these negotiations and talk about things on a conceptual level. Keith, we've ended up with 29 very broad reps and warranties that cover the universe, and an indemnification provision with customary limitations where I concede you've been reasonable. And as you know, these reps, warranties, and indemnification provisions and limitations are basically risk allocation provisions. And after a week of tedious back and forth, we arrived at what I would call a mutually acceptable allocation of risks between the parties. Do you agree?
I do agree with that, Rick. It is all about the sharing of risks, and I thought we did a good job on that.
Okay. So given all that, what I'm inclined to do, Keith, is to delete all of your fraud-related provisions and replace them with one single disclaimer. A disclaimer providing that the buyer has no separate remedies for fraudulent misrepresentations. That's because the buyer already has this powerful indemnification remedy, subject to the limitations we've negotiated, for all inaccurate representations made by the seller, whether they be fraudulent or innocent. And I propose that fraudulent misrepresentations be treated no differently than innocent misrepresentations. The economic harm to the buyer is no different in either case. It shouldn't matter whether the seller knew the representation in question was wrong. the risk allocation should be the same either way. So no special remedies for fraud. Your client's indemnification remedy is sufficient and is consistent with the agreed allocation of risks.
Rick, that makes absolutely no sense to me. If your client commits fraud, all bets are off. And the limitations we negotiated, the 10% cap, those just don't apply. If my client can prove that your client made a false statement in the agreement with nefarious intent, knowing it was false, we need to have unlimited fraud remedies.
But why? Why should it matter whether the breach of the rep was innocent or deliberate? Just because of some vague moralistic feeling you have that lying is bad and needs to be punished?
Yeah, Rick, I guess that you're more tolerant of dishonesty than I am.
I'm just saying that in this case, alleged dishonesty on the part of my client shouldn't matter economically. Why do you think it should?
Rick, I can answer that in 3 words. Fraus omnia vitiat.
Keith, I can barely understand you when you speak English. What the hell language was that, Latin?
Yeah, it was Latin. It's a Latin maxim. I know you hadn't heard of it, but it means that fraud vitiates everything. It vitiates everything it touches. And so fraud, in this case, trumps everything, including the artificial limits on indemnification.
Okay, now, Keith, I've obviously never really thought of you as a Latin scholar. I must admit, you do sound very scholarly when you speak Latin.
Thank you.
Well, actually, maybe not really. But those are just words. And I'm going to respond in kind with another Latin maxim. And it, too, is only 3 words. Flocci, non, faccio.
Talk about what? And what are you talking about? What does that mean?
Well, I know your Latin is a bit rusty, but it means I don't give a Look it up. I just can't care.
I know you don't care about Latin maxims, but let me mention something that you should care about, and that's Delaware law. So I've got a copy with me of then Vice Chancellor Strine's opinion in the Abry Partners case. And he makes it very clear that what you're proposing to do, which is to disclaim liability for fraud with respect to the reps in the stock purchase agreement, that just won't fly. You can't do it. The disclaimer is invalid and unenforceable. If your client makes reps in the agreement and they lie about them, they're liable without respect to the caps. That's what the law says.
Keith, you got me. I take your point, and I'll back off. Far be it from me to contradict the wisdom of Leo Strine, one of my favorite judges. But then Vice Chancellor Strine makes another point in that very same decision that I do want to pursue. He points out that even though a buyer can't validly disclaim fraud with respect to reps made inside the acquisition agreement, a buyer can validly disclaim fraud relating to reps and other statements made outside the agreement, extra contractual fraud. That's what I want to do here. I want to validly disclaim fraud relating to reps and other statements made outside the acquisition agreement.
So wait a minute, Rick. You mean that you want to disclaim liability for everything your client's been telling us in the due diligence sessions that we've having?
Well, if it's not in the acquisition
management
agreement, if
presentations,
there's no rep relating to it, yeah.
How are you going to disclaim that?
Well, we're going to disclaim it with a simple boilerplate provision in the stock purchase agreement, Keith, called a non-reliance clause. The clause would say simply that, except for the express written representations made by the seller in the stock purchase agreement, the buyer is not relying on any representations or other statements made by the seller. Because remember, reliance, remember that slide that Jane put up that showed that reliance is a necessary element of fraud? No reliance, no fraud. And in the Abry Partners opinion, Judge Strine made it clear that under Delaware law, a properly drafted non-reliance clause works to eliminate the purchaser's liability for extra contractual fraud. It works. It may not work under other states' laws, but our stock purchase agreement, as you know, is governed by Delaware law, so it works.
Great. It works. But why in the world do you think I would ever agree to it? The fact is, my client, the buyer, is relying on everything your client said during the due diligence sessions. That's why it's having the sessions. So why would I say in the agreement my client is not relying on it? It is relying on it.
Well, just tell your client not to rely on anything outside the four corners of the stock purchase agreement. I'm not saying that facetiously. If there's a statement that we make that it's truly relying on in the sense that it's central to your client's decision to do this deal at this price, then enshrine that statement in an express written rep in the stock purchase agreement, and you'll be covered. Simple as that.
You've just spent weeks complaining about how long the reps and warranties are, and now you're saying enshrine them. But more fundamentally, you're telling me to give you and your client a license to lie. Your client could just make stuff up during the due diligence and have no liability for doing that. Why don't you ask your client what they want to lie about? They could tell me, and I'll ask my client if that's okay.
Keith, I say again, we are willing to stand behind the statements we made if you're really relying on them. And if there's a statement like that, enshrine it in an express rep in the stock purchase agreement. Look at this from our point of view, Keith. If we don't get this non-reliance clause, and your client, for any reason, is disappointed after the closing with the business that it bought, it will scour its due diligence files and its notes of all the conversations that we had, all of these extra contractual conversations and due diligence presentations and everything else. It will scour all of them and then sue the seller for extra contractual fraud. Or even worse, it will claim that the seller made these inaccurate oral statements that weren't even made, and then allege fraud. And it will do this even though every single representation in the acquisition agreement was 100% accurate. My client can't accept that risk.
Look, Rick, my client is not going to give up the right to recover for extra contractual fraud. It has that right today, so we're not going to give that up. But what I will do is I do have a compromise. I know you love compromises. So I have seen that language you proffered, the non-reliance language. We'll accept that language, but we just want to add a few words at the end of it that basically says, fine, we'll accept the language that we won't rely on things, but that language won't prohibit my client, the buyer, from bringing a case for fraud, including outside the four corners of the agreement. What do you think?
Well, let me read this, Keith, this exception in red here. Keith, I thought we were negotiating constructively and in good faith. Of all the circular and non-convincing points you've made today, this may be the most outrageous and disingenuous of all. What good is a non-reliance clause to me if you give it to me with one hand and then take it away, completely negate it with the other? The answer is no. I'm insisting on a non-reliance clause without a fraud carve-out. And let me just end things right here now. Jane, the deal point studies don't give us reliable statistics on this point, but in your experience, does the buyer typically win this point, at least in the deals we do with large cap buyers against privately held tech companies? In other words, does the buyer get either no non-reliance clause or a non-reliance clause with a fraud exception that swallows up the non-reliance clause?
Well, Rick, in my experience, strategic buyers are generally very successful in preserving their remedy for extra contractual fraud for all the reasons that Keith just stated during your negotiation. I personally, and frankly, most of our clients don't find the seller's arguments particularly persuasive on this point. There are far less nuclear ways of addressing that concern.
Like, don't commit fraud.
So, Keith, you should feel entirely justified in winning that negotiation.
Right.
I do.
As should all of our buy-side, large cap, small cap, and mid cap companies as well.